It is now my pleasure to turn today's program over to Scott Hunter. Mr. Hunter, the floor is yours.
Hello, we'd like to welcome everyone to the OSAA ALICOMP webinar series. This particular webinar is going to cover the topic of OSHA recording, reporting, and record keeping of occupational illnesses and injuries. Today we're going to have Rick Hunter from Alabama Risk Management and SafetyInfo.com presenting our information. So with all that being said, we'll go ahead and turn it over to Rick.
All right, thank you. Like Scott said, we're going to talk about 29 CFR Part 1904, talk about record keeping and recording, reporting accidents and injuries, illnesses, and some of that's changed over the last year or so. So we will try to answer questions and try to give you a good description of what's going on. Organization of the rules. If you look at this, you'll see a lot of different subparts listed in, and there are reasons. These are kind of like subtitles. Subpart A explains the purpose of the rule. Subpart B explains the scope. Subpart C is forms and recording criteria. Subpart D, other requirements, and that's something we really want to pay attention to. Subpart E, reporting of the government, and then Subpart F, transitions, and Subpart G, definitions, which sometimes really helps you out a great deal. Let's look at the purpose for the rule, and I think a lot of people really understand this, but let's dig into it and just see. The purpose of the rule is to require employers to record and report work-related fatalities, injuries, and illnesses. And we know some of the reporting criteria have changed over the last year, but also note that recording or reporting a work-related injury, illness, or fatality does not mean that the employer or the employee was at fault and an OSHA rule has been violated or that the employee is eligible for workers' comp or any other benefits. And that's important to know that. OSHA injury and illness record keeping and workers' compensation are definitely two independent things and need to be thought about independently. Subpart B is the scope. And this is something I hope you'll take note of, especially when we look into these parts of 1904.1, the small employer partial exemption. 1904.2, industry partial exemption. Also subpart B for a complete list. So there's a listing in there that's really important to see what your exemption is. 1904.3, keeping records for other federal agencies, which I don't think we'll dive in too much for this particular webinar. Now, when we talk about partial exemptions, employees that are partially exempt from the record-keeping requirement because of their size or their industry must continue to comply with 1904.39. Now, that's where we get into reporting fatalities, amputations, the loss of an eye, or an inpatient hospitalization of one or more employees. Now, remember, that changed at the 1st of January of 2015, and now that you have the requirement of reporting a fatality within 8 hours, but an amputation, a loss of an eye, or an inpatient hospitalization of one or more employees is 24 hours, and you have to report that to your local OSHA office. 1904.41, annual OSHA injury and illness survey, if it is specifically requested to do so by OSHA. So remember, also 42 is the BLS, the business legal statistics that you may get at the end of December, which will be for the year coming up. So if you receive one of these from BLS, the annual survey, in December of 2015, it will be for the year of 2016, and at the end of 2016, you'll need to mail that in. A lot of times it will go to your state, and then from the state it will go to the federal government. Most cases, it'll go to the Department of Industrial Relations. This is a chart that I've drawn up. It's just kind of a decision tree that will help you if you need to report or not. If you'll see at the top, it'll say employee is injured. The decision there is, was it fatal? No. Was the employee admitted to a hospital? No. Was there an amputation? No. Did someone lose an eye? No. Then there's no report required. So just use the decision tree as a tool to determine whether you need to report or record this particular injury. Size exemption is in 1904.1, and again, if you keep up with these, you can go back to those particular subtopics and figure out exactly rule applies to you. But if your company had 10 or fewer employees at all times during the last calendar year, then you do not need to keep an injury and illness records unless surveyed by OSHA or the BLS. If they send you something asking for your records, then obviously you have to keep them and send them in to them. The size exemption is based on the number of employees in the entire company, includes temporary employees who you supervise on a day-to-day basis in that count. Now, this is something that's a really serious topic right now, and that is whether they're employees or whether they're temp force employees. If they're temp force employees and you're the one who's doing the supervising, then you include them on your log. If the temp force has a supervisor inside your facility that belongs to the temp force and they're the ones who is actually doing the day-to-day supervising, then that injury or illness may go back to that temp force. So that's something we really want to keep an eye on as we move forward. Industry exemptions, all industries in agriculture, construction, manufacturing, utility, wholesale trade sectors, all of those are covered. In the transportation, retail, and service sectors, some industries are partially exempt. A good case of that is there are some transportation industries where a lot of their work is covered by the Federal Motor Carrier Safety Administration, which may not go on an OSHA log. Also, if you look at Appendix A to the Subpart B, that lists all of the partial exemptions of the industry. So another list you might want to look at if you're wondering if you're exempt or if you must comply with this rule. Recording criteria, this is Subpart C, the record-keeping forms, record-keeping criteria, things of that nature. As you can see, it goes through point 4 down to point 29. And it skips around in different places, 4 being record-keeping criteria, 5 being work-relatedness, 6 being new cases. That's really good information when you're trying to decide whether that needs to go on your OSHA 300 log or not. Record-keeping criteria, covered employees must record each fatality, injury, or illness that is work-related and is a new case and meets one or more of the criteria contained in this section 19047 through 19041. So that's something you would probably want to go to, and if you had the opportunity to print it off or keep it close by, it could probably help you with a lot of decisions. Now, OSHA injury and illness record keeping, there's a 5-step process that we like to look at. Did the employee experience an injury or illness? Is the injury or illness work-related? And is the injury or illness a new case? Does the injury or illness meet the general criteria of the application or specific cases? If so, then record the injury or illness. And again, going back to that criteria and be able to look at all that is a huge help to you when you're trying to make that decision. Now, let's look at this. It said, did the employee experience an injury or illness? And we'll go to the next slide. It says, an injury or illness is an abnormal condition or disorder. Injuries include cases such as, but not limited to, a cut, fracture, sprain, amputation. Illnesses include both acute and chronic illnesses, such as, but not limited to, skin disease, respiratory disorder, or some type of poisoning. Let's take a look at some examples. Here's step 1. Did the employee experience an injury or an illness? Here's scenario B. There is a chlorine gas leak at XYZ establishment, and 2 employees in the area are rushed to the hospital. They are told to stay home the next day as a precautionary measure. Do we stop here, or do we go to the next step? And it's something I'd ask you to do. Keep that word in mind, precautionary measure, because I think that is going to be really important as we move forward. Now, one of the things that we have to determine is the injury or illness work-related? Now, in this particular scenario, the work-relatedness is presumed for injuries and illnesses resulting from events and exposures occurring in the work environment unless an exception specifically applies. Now, the case is presumed work-related if and only if an event or an exposure at the work environment is a discernible cause of the injury or an illness. And if you remember, they were only sent to the hospital as a precautionary. So really what you had there was you had an exposure. You really didn't have an illness at that particular point because they were only monitored as a precautionary basis. So we have to keep that in mind. Now, in 19045 in the work environment is described as an establishment or other location where 1 or more employees are working or present as a condition of employment. The work environment includes not only physical location, but also the equipment and materials used by the employees during the course of their work. And something you hear a lot of times is course and scope. If they're in the course and scope of their duty, then they may be something you have to record, or again, it may roll into a work comp case. Now, 19045 says significant aggravation, and this is something that we deal with quite a bit. A pre-existing injury or illness that is significantly aggravated when an event or an exposure in the work environment results in any of the following, which otherwise would not have occurred: death, a loss of consciousness, days away from work, days restricted for job transfer, and or medical treatment. Exemptions are present as a member of the general public, symptoms arising in work environment that are solely due to non-work related event or exposure, regardless of where the signs and symptoms are, a case of work related only if the work event or exposure is discernible cause to the injury or illness or a significant aggravation to a pre-existing condition. I know that's a lot of wordy stuff, but that's kind of the way the regulation is worded. Also, an exemption is a voluntary participation in a wellness program, medical, fitness, recreational activity, eating, drinking, or preparing food for personal consumption. And that list can really go on, and that's where you really need to refer back to the regs. Here's some more exemptions: personal tasks outside assigned working hours, personal grooming, self-medication of non-work-related conditions, intentionally self-inflicted, motor vehicle accidents. Now catch this: motor vehicle accidents in the parking lot, access road during the commute. Common cold or flu is also an exemption. Mental illness, unless the employee voluntarily provides a medical opinion from the physician or licensed healthcare professional, and they've confirmed that. So when you look at this list, be sure to look over it carefully, because there are a lot of different detailed information that could be exempt from the OSHA 1904 recording log. Now, travel status is something that comes up from time to time. 19045 also speaks to the travel status. An injury or illness that occurs while an employee is on travel status, if work-related, if it occurred while the employee was engaged in work activity in the interest of the employer, home away from home, or detours for personal reasons, is not work-related. And from time to time, people that have outside sales forces and people like that, they do run into these questions from time to time. And another one that's really big right now is work at home. Injuries or illnesses that occur while employees is working at home are work-related if they occur while the employee is performing work for pay or compensation in the home and are directly related to the performance of work rather than the general home environment. And that's something that we certainly have to keep. We have more and more people have home offices today, and this could occur. So 1904.6 talks about the new cases. If there's a medical opinion regarding resolution of a case, the employer must follow that opinion. If an exposure triggers the reoccurrence, it is a new case, such as asthma or rashes or something along that line. If signs and symptoms reoccur even in the absence of exposure, then it is not a new case, such as silicosis, tuberculosis, asbestosis, something along that line. Here's another example. It says, is it an injury or illness? Is it a new case? Let's see what the example is. Scenario B, 5 weeks ago, employee sprained wrist at work and received support, prescription medication, and light duty. 2 weeks ago, the employee was back on the normal job but continued to take prescription medication. Today, 5 weeks after the injury, the employee complains of pain in the same wrist after moving boxes. So keeping that in mind, do we stay here or do we move on to the next step when it comes to recording this particular injury or illness? So here's what we're saying. General recording criteria: if the injury or illness is recordable, if it results in one or more of the following: days away from work, restricted work area, transferred to another job, medical treatment beyond first aid, and loss of consciousness. 1904.7 talks about the days away from work. And if you look in the regs, you can always Google this. If you look in the regs at 1904.7B3, then it gives you all the regulations and all the information you need about days away from work. Record if the case involves one or more days away from work. Check the box for days away from cases and count the number of days. Do not include the day of the injury or the illnesses. So if the injury happened today, you don't count this day, but you start counting the calendar days starting on the next day for as many days that they are away from work. Count days away or restricted. Count the number of calendar days the employee was unable to work, including weekend days, holidays, vacation days, and so on. And something that I've seen safety directors miss a number of times, cap the count of days at 180. Once that employee has been away from the job or days away from work for 180 days, you stop counting there. Don't go into 200 or 213 because that's going to elevate your DART. So be sure to cap it at 180. May stop day count if the employee leaves the company for a reason unrelated to the injury or illness. And if the medical opinion exists, the employer must follow that medical opinion. Let's talk about restricted work cases. Record the case involved record if the cases involve one or more days of restricted work or job transfer. Check the box for restricted transfer cases and count the number of days, but do not include the day of injury and illness. That date is never counted. It always starts on the next day. Restricted work case. Restricted work activity exists if the employee is unable to work a full work day, he or she would otherwise have been scheduled to work, or unable to perform one or more routine job functions. An employee routine job function are those activities that the employer regularly performs at least one per week. 19047 talks about restricted work cases. The employee experiences minor musculoskeletal discomfort. The healthcare professional determines that the employee is fully able to perform all of his or her routine job functions, and the employer assigns a work restriction that the employer to that employee for the purpose of preventing a more serious condition from developing. Job transfer. All injured or ill employees is assigned to another job as part of his or her regular job for part of that day. A case is recordable if the injury or illness of the employee performs his or her routine job duty for part of that day or is assigned to another job for the rest of the day. Medical treatment. 19047, 5B, or B5, I'm sorry. Medical treatment is the management and care of a patient to combat disease or disorder. It does not include visits to a physician, licensed healthcare professional solely for observation or some kind of consultation, diagnosis procedures, or first aid. So remember, those are not necessarily recordable. Using non-prescription medication at non-prescription strength, some kind of tetanus shot or immunization, cleaning, flushing, or soaking of surface wounds, wound covering or butterfly band-aid, stair strip, something along that line, hot or cold therapy, non-rigid means of support, temporary immobilization device used to transport accident victims. First aid, 19047B5, talks about drilling the fingernail or toenail or draining fluid from a blister, an eye patch, or removing foreign bodies from the eye using irrigation or cotton swab, removing splinters or foreign material from areas other than the eye by irrigation, tweezers, or cotton swab, or other simple means, finger guards, massages, or some type of drinking fluids for the relief of heat stress. Those are things also that would fall under first aid and wouldn't necessarily need to be recordable. Significant diagnosis, injury, or illness, the following work-related condition must always be recorded at the time of diagnosis by the physician or the licensed healthcare professional, some type of cancer or chronic irreversible disease, punctured eardrum, fractured or cracked bone or tooth, or something like along that line. Bloodborne pathogen, when we get into the medical industry, especially record all work-related needle sticks and cuts from sharp objects that are contaminated with another person's blood or other potentially infectious material, including human body fluids, tissues, or organs, or other materials infected with HIV, HBV, such as laboratory cultures. Record splashes or other exposures to blood or other potentially infective material if it is a result of a diagnosis of a bloodborne disease or meets the general recording criteria. Medical removal. If an employee is medically removed under the medical surveillance requirements of the OSHA standard, then you must record the case. The case is recorded as either one involving days away from work or days of restricted work activity. If the case involves voluntary removal below the removal levels required by the standard, then the case need not be recorded. Hearing loss is something that from time to time we have to experience, especially if we're in a loud noise environment. Must record all work-related hearing loss cases where the employee has experienced a standard threshold shift in SDS, or the employee's hearing level is 25 decibels or more above audiometric zero, averaging at 2,000, 3,000, and 4,000 hertz, which is typically the voice ranges, the voice frequencies, in the same ear as the SDS. And some of that sometimes can get very complicated. Tuberculosis is another one, 1904-11. Record a case where an employee is exposed at work to someone with a known case of active tuberculosis and subsequently develops a TB infection. The case is not recordable when a worker is living in a household with a person with a diagnosis of active TB. The Public Health Department has identified the worker as a contact of an individual with active TB, and a medical investigation shows that the employee's investigation was caused by exposure away from work. There are a number of different forms that we have to use, 1904-29 forms, OSHA Form 300, the log of work-related injuries and illnesses, the 300A, which is the summary of work-related injuries and illnesses, and the 301, which is the injury and illness incident report. This is a good look at the 300 log, which I'm sure most people are familiar with. This is the 301. And this is the 300A. Now keep in mind that when you do a 301, which is the injury and illness incident report, if you're in Alabama and you're providing a Alabama first report of injury that goes to your work comp, keep in mind these forms are the same. They may not be in other states, but in Alabama, the first report of injury going to your work comp carrier and your OSHA 300 form or the 301 form is the same form. One thing you will need to do is make a copy of your first report of injury and put it with your 300 log to suffice that regulation. No need to double the paperwork if it's not necessary. 1904-29, employer must enter each recordable case on the forms within 7 calendar days. I've seen OSHA write citations for missing this, but just keep in mind each recordable case should be on the form within seven calendar days of receiving information that a recordable case has occurred. So you really want to pay attention to that and make sure you get it on the form quick enough. An equivalent form has the same information and is readable and understandable and uses the same instructions as the OSHA form. It replaces the form. They can be kept on a computer as long as they can be produced when they are needed, meets the access provisions of 1904-35 and 1904-40. And that's what I was talking a moment ago about the 301 and the Alabama first report of injury. But check your local state just to see if you have. Typically, you can look at the top right of the form, and if it has a slot there that says OSHA case number, then it is the same form as the 301 in most cases. Now, we talk about privacy protections. Says do not enter the name of an employee on an OSHA 300 form for privacy concern cases. Enter privacy case in the name column. Keep a separate confidential list of the case number and the employee's name. Sometimes there are some cases that the sensitivity of it can be an issue. Privacy protection. Privacy concern cases are employees that use discretion in describing the case, if the employee can be identified, is if you can give the forms to people not authorized by the rule, you must remove the names first. Exemptions are obviously auditors and consultants, workers' compensation or other insurance, public health authority, and also law enforcement agencies. Other requirements, you see 1904-30 through 1904-38, and then we talk about the multiple business establishments, which there is some confusion out there with some. I've run into it a number of times. Covered employees, annual summary, things of that nature, and that's what we'll talk about next. Multiple business establishments. Keep a separate OSHA Form 300 for each establishment that is expected to be in operation for more than a year. So if you have multiple facilities in Alabama, or maybe you have a facility in Alabama, maybe one in another state, remember, keep a separate form for each one of those. It is okay to keep a corporate form because that is information, but for compliance purposes, you want to make sure you keep a separate form for each location. May keep one OSHA Form 300 for all short-term establishments. If they're going to be less than a year, each employee must be linked with at least one of those establishments. So if you have employees that are moving around, you need to link them to at least one of those establishments that they would be working from. Covered employees, employees on the payroll, employees not on the payroll who are supervised on a day-by-day basis, exclude self-employed and partners. Temporary health agencies should not record the case experiences by temp workers who are supervised by the using firm. We talked about that earlier. If the temp agency has a controlling supervisor in there, then it goes to the temp agency. But if they're not and your firm is doing the day-to-day supervision, then that injury or illness would go on your 300 log. Annual summary, this is in 1904-32. Review OSHA Form 300 for the completeness and accuracy and correct any deficiencies. Now, I have seen citations in the past where someone was writing in an OSHA 300 form, and instead of clicking or drawing an X in Category H, they had it over in Category J, and I saw the citation for $300 for each error that was on the OSHA 300 log. Now, in order to abate that, all we had to do was rewrite the OSHA 300 log and put the X's in the right place. And so be sure to look over that for accuracy because it's really important in the event of an inspection. The annual summary, a company executive must certify the summary. The owner of the company, an officer of the company, the highest ranking company official working at the establishment or his or her supervisor. Must be posted for a 3-month period beginning in February 1 through April 30th. So we're in that period now where your annual summary should be posted. And, of course, it covers following the year. Like right now we're in 2016, so we're posting the 301, the annual summary for the year 2015. Retention and updating retain forms for 5 years following the year that they cover. So a lot of people question, how long do we need to keep these forms? So the answer is 5 years. Update the OSHA form during that period. Need not update the OSHA form or the 300A form or OSHA 301. So if you had something to change in that year period, you can update the 300, but there's no need to change the 300A or the 301. Employee involvements in 1904.35 says you must inform each employee of how to report an injury or illness. Now, I run across this from time to time, and again, this is another area where I've seen 5A1 citations come out under the general duty clause because they had some injuries and the employee had no idea what to do. Most people say, look, report this to your immediate supervisor, and the immediate supervisor will take it from there. Sometimes it's as simple as that, but the employee being asked in some kind of OSHA where they're interviewing the employees after something happened and they answer, I don't know, and that could probably get you a 5A1. So you want to make sure, even though it seems like it's common knowledge across the board of how to report an injury, make sure the employees understand the steps. They must set up a way for an employee to report work-related injuries or illnesses promptly, tell each employee how to report that work-related injury or illness to you, whether it's through the Human Resource Director, or maybe it's through the supervisor or whoever it might be. Now, 35 is employee involvement. Must provide limited access to injury and illness records to employees, former employees, and their personal and authorized representatives. Obviously, provide a OSHA 300 form by the end of the next business day. Provide a copy of the 301 to the employee, former employee, or personal representative by the end of the next business day as well. Provide copies of 301 to authorized representatives within 7 calendar days, and provide only information about the case section of the form. Against discrimination, this is in Section 11C. You'll hear this a lot. This is sometimes called Section 11 is called the whistleblower. Section 11C prohibits against discrimination of all acts, prohibits you from discriminating against your employee for reporting a work-related fatality, injury, or illness. Section 11 also says, also protects the employees who files a safety and health complaint, asks for access to part of the 1904 records, or otherwise exercises any of these rights afforded by the OSHA Act. So if you forget about Section 11, you can always go to the whistleblower portion and read some of these regulations. We don't talk much about state plans. There are, I think, 24 states right now or so that have state plans. State plans must have the same requirement as the federal OSHA for determining which injuries and illnesses are recordable and how they are to be recorded. Other parts of 1904 requirements, state plans require, may be a little more stringent. They may change some things. So if you have a state agency in your state, and you want to make sure that you look at their state plan. 1952.4 also modifies and reflects these concepts. So just remember, if it's a state agency, you may want to dig a little bit deeper to see that they didn't add on to the record-keeping portion of 1904. Subpart E is reporting information to the government. This goes on every day somewhere. 1904-39, fatalities and catastrophe reporting. 1904-40 is access for government representatives. 1904-41 is the OSHA survey, and then the 1904-42 is the BLS survey. So if you get a package in the mail, it typically comes in December, and it's labeled BLS, and it has an OSHA 300 log inside. It will have a description of what you need to do. That is regulatory. You have to do that. Now, we talked about some of the changes earlier in fatalities or catastrophe-type reporting. Now, remember to report within 8 hours any work-related fatality. Report within 24 hours any work-related amputation, loss of an eye, or inpatient hospitalization of one or more employees. You do not need to report highway or public street motor vehicle accidents outside of a construction zone, and you do not need to report commercial airplane, train, subway, or bus-type accidents. 1904-40, providing records to government representatives must provide copies of the records within 4 business hours. Now, sometimes people read into that and they're thinking 4 business days, but it's really 4 business hours. Use the business hours of the establishment where the records are located. So if they're on Eastern time and it's 9 o'clock, then obviously it's 4 hours from that establishment. For more help, look at the OSHA record-keeping page, OSHA regional record-keeping coordinators, state plans, OSHA Training Institute Education Centers, and you can also go to www.safetyinfo.com and get more information. So this wraps up this section of 1904, record-keeping for reporting injuries and illnesses, and I know there will be a question and answer session, and so we'll prepare for that.
All right, and we want to thank everyone for logging in and viewing this OSAA and ALACOMP webinar. And again, if you have any questions, just send those in through the chat box. The ones that aren't answered immediately, we will get a response back to you within the next 24 hours.
And as a reminder, you may ask a question through your web console. Locate the Q&A panel on the lower right-hand side of your screen. Type your question in the open area and click Send to submit.
See a question here from Pam, and I want to try to answer this for you, Pam. If you are the same company with multiple locations, do you have to keep a separate OSHA log? And the answer to that is yes. If you have multiple locations, whether they're all in the state of Alabama or whether you have one in Alabama and maybe several spread out through the Southeast, I would always recommend you to each individual facility keep their own OSHA log. Now, there's nothing wrong with keeping a corporate log for information so that everybody reports up to the corporate administration and they're all on the same page. But the answer to that is, in my mind, without a doubt, I would keep a log for each location. I see a question here from Patsy. It says, we are now in charge of a new plant. They did not leave the OSHA 300 log. Is it correct to just start our 300 log as of April 1, the date we took over? Yeah, I would think so, Patsy, that if you're taking over a new plant, they didn't leave you one. If this is a new business, then, yeah, I would pick up my OSHA 300 log off my first day of business. And Lisa's asking if she may obtain a copy of the slides, and Kelly and Scott, I think they can have these slides. Am I correct?
Yes, yes. A copy of the presentation will be available on the website.
Yeah, and Patsy, you're welcome. Any other questions? Okay, that appears to be all the questions.
Okay, if there's no other questions, well, I think we do have another question.
Yeah, Gladys says that also our company is an outsourcing company for a plant here in Montgomery. Do I need to record, do I need to the records from the company that we staff? Now, let me make sure I understand the question very well. It says also our company is an outsourcing company, outsourcing employees, Gladys, or outsourcing services? Employees, okay, thank you. Do I need the records from the company that we staff? Here's the question is, if you're outsourcing employees, are you supervising those employees at their location, or is the company you're outsourcing to doing the supervising and daily activity of those employees? And the answer is we have supervisors on site, and they also supervise. Yeah, if you're supervising those employees on site, then I would make sure I had all the information for your 300 form to make sure that you get that recorded. If the other company was supervising them, then I would say, without a doubt, let them record them. But if you're supervising them, yeah, you're going to need all that information and also record it. You're welcome, Gladys. I think Tamika also said, will I be able to print these when we are done? She's asking about the slide presentation. Will she be able to print the slide presentation when we're finished?
Yes, on the website, you'll be able to download the actual presentation, or you'll be able to download the slides, either or. She can download the slides and then print those.
Yeah, okay, very good.
Do we have any other questions?
Okay, very good. Thank you.
All right. Yeah. If there's nothing else, then we'll close the webinar. Thank you all for your attendance.
Yeah, Scott, it might also, if maybe someone might think of a question later on, I'm sure there's a place they can email that question into you guys. And Teresa's asking, which website are you referring to?
It is www.alicompins.com, the Alicomp website. It's alicompins.com.
All right, good.
Okay. All right. Thank you all.
Okay. Thank you again for joining us today. This concludes today's web conference. You may now disconnect.